Jennifer Westfield was suing daycare provider Christina Tinzley-Williams for medical bills and damages resulting from neglect. Jennifer had a 10-month-old baby who she took to Christina's daycare. The baby put something in his mouth, which was removed by the daycare provider. Jennifer was now suing for medical bills and damages for neglect. Judge Judy presided over the case, questioning both parties. Christina claimed that sometimes babies pick up things and she might have taken her eyes off the baby for a second, but she saw him put it in his mouth and was trying to remove it. On the other hand, Jennifer had 3 children, 2 of whom had attended Christina's daycare for 2 years, and she was otherwise satisfied with the service. The incident in question occurred on August 12, 2016, and Jennifer's other 2 children had never been to the emergency room. However, her 10-year-old had required surgery after a skating accident. Jennifer had started taking the baby to Christina's daycare because she was working, and the baby had spent 3 weeks there without incident prior to the August 12th incident. The judge noted that Jennifer had a perfectly fine experience with Christina for several years and was taking the baby to her daycare because she was working. On the day of the incident, Jennifer wasn't there and arrived later when they were trying to remove whatever was in the baby's mouth. Christina confirmed that the incident took place on August 12th. Judge Judy was conducting a hearing involving Ms. Williams, a licensed child care provider in California. The judge asked Ms. Williams how many children she was caring for on the day in question, and she replied that there were 7 school-aged children and a newborn. Judge Judy also asked about the number of people watching the children, and Ms. Williams said that she had 2 assistants, both 25 and 27 years old, and was taking care of children in her home since 2008. When asked if she was licensed, Ms. Williams confirmed that she was and that she was still licensed in California and had never had her license revoked. The judge then asked about the incident involving Ms. Westfield's baby. Ms. Williams explained that they were doing arts and crafts when one of the assistants noticed the baby grab a bubble sticker. When the Lady Williams tried to get it out of the baby's mouth, the assistant wanted to take him to the hospital. The sticker was on the top of the baby's mouth but not in the back of his throat, and was not causing choking. Ms. Westfield, the mother of the baby, then interjected to add more context to the story. She said that when she arrived at Williams' house, her son was being held down on the ground while they tried to get the sticker out. Ms. Westfield was able to remove a wood chip and a piece of plastic comb from her son's mouth, but the sticker was still lodged in the back of his throat. They took the baby to the emergency room. Ms. Westfield explained to the judge that her baby had been taken to the emergency room after he swallowed a sticker and a piece of plastic comb. Despite her efforts to remove the foreign object, a pediatric specialist had to be called in to take it out, which ended up tearing the roof of the baby's mouth and causing him to have a fever for a week. Judy asked to see the medical report and bills related to the incident. Ms. Westfield presented 2 bills and copayments for the fever and the emergency room visit, which had already been paid. She also mentioned that the baby had a subsequent hospital stay for an abdominal infection, but that was in December. Judge Judy asked if there was any connection between the sticker incident and the baby's later health issues. Ms. Westfield stated that she did not see a direct connection. The judge then asked if the baby was taken to another daycare after the incident, to which Westfield replied that she stopped working and was now taking care of the baby at home. Ms. Williams, the defendant, told the judge that she had liability insurance, but she presented a letter from her attorney stating that she did not have liability insurance. Judy asked to take a look at the copy of Ms. Williams' liability insurance and determined that the issue should have been resolved a long time ago by sending a check to cover the out-of-pocket medical expenses. In the end, the judge ruled in favor of the plaintiff, Ms. Westfield, and ordered Ms. Williams to pay $200 to cover her medical expenses. The hearing was over.